Sean?
No, you're
If you want me up there, I'll get up.
If you want him up here, he'll come up.
You can see where.
Oh, no, this good.
Zoom right in our window.
Is this supposed to be smooth?
No, I'll explain.
No, that's fine.
Yeah, that's right.
You don't have to explain it. You just-
20, 30, 40 years. There's lots of
Right through, over print, there, right through, right through. Okay. I see what you.
Well, you know, if you remember, we were making fun of French. But they were whims recently, something with the French fries. They ended up saving our Easter. Send them a statue of Liberty. They ended up sending us a statue.
So.
It
Everybody
is.
knows my walker, but nobody knows I'm losing my gut.
I just jealous.
Hi, Lance.
Peter is not diabetic, and Peter's diabetic.
Yeah.
He,
You have reached the town.
we started the diabetic.
Please enter your.
5 weeks. We lost 18 pounds. I lost a pound and a half. He was
Okay, welcome everybody. This is a public hearing on change recommendations that were presented by the town planning board to the town board, as well as the town board in looking them over. And we are looking at this being close to being the final and submitting them to the county. What you have in your hands is a copy, and if you look into it a little bit further, you'll notice that there are sections where there are sentences or words that are crossed out. That indicates a word or sentence that is recommended to be removed from the solar law. And that word's in bold print within the context. That is what is being added, the recommendation to be added to the solar law. There is one other change in here that was not caught until the planning board met on Monday and they brought it to our attention. And that is on page 8. Page 8, which is under 350-119, letter L as in Lincoln. Towards the bottom of the page within the context of number 4, there should be indications on your page showing that where the sentence starts, all expenses or costs of establishing or maintaining financial assurance and all the rest of that, and the bold, would then become number 5. It is not part of number 4, it is part of number 5. And that should be indicated on yours already. Correct me if I'm wrong. Okay? Yeah. Yeah. Okay, to make it all official, notice of public hearing, please take notice that a public hearing will be held on April 14th, 2021 at 6 p.m. at the Berry Town Hall, 14317 West Berry Road, Albion, New York, 14411. The purpose of the public hearing is to consider adoption of proposed law number 2 of the year 2021, amending chapter 350, article 12, sections 350-11, 350-117, 350-119, and adding section 350-123 of the Town of Berry zoning ordinance referencing solar energy systems and facilities. A summary of the proposed amendment is a summary of the proposed amendments is as follows. A, clarifying that the approval authority for applications is the town board with recommendation of the town planning board. B, eliminating setback requirements for two or more contiguous parcels that have a lease agreement with the applicant. C, amending the requirements for a decommissioning bond and plan. D, adding a provision requiring that an applicant for a utility scale solar energy system. E, enter into a host community agreement with the town of Berry to I, compensate the town for expenses or impacts on the additional agreements as may be necessary to protect the town's and citizens' interests, and really it's two, to establish an escrow account for payment by the applicant for engineering costs and legal costs incurred by the town. Letter E, technical corrections. A full copy of the proposed law number 2 of 2021 is available for inspection at the office of the Berry Town Clerk, 14317 West Berry Road, Albion, New York, dated March 11th, 2021, Marine Beach, Town of Berry, Town Clerk.
Say that it was published. Let them know that it was published in the paper.
It was published in the paper, yes.
Okay, and then I just have questions. Number 2, that's present here this evening. Number 2, Charles, is that McAllister?
Yes.
Okay, and number 3, Mark, the last name,
Lindbergh,
can you spell that?
Lindberg.
Thank you.
We also have in attendance from the planning board, Wes Miller. Board members are all here, as well as the town attorney, Lance Mark. Okay. Everybody have a chance to kind of peruse this a little bit? Any questions you may have? Anything you want to add to it, Wes?
No.
Okay. Yes, sir.
I have a question about setback requirements. Setback requirements are measured from structures on non-participating property from the building to any portion of the solar facility, which would mean that the solar facility is using a portion of your property for their setback. Is that correct? Am I stating that clearly enough? They're not measuring setbacks from their property line, they're measuring from the homeowner's property.
From the homeowner's property line.
Doesn't say property line, I believe. That should be clarified.
What page and section is it
I
on?
believe that's on 7 or 8. H.
H, yeah, setbacks. Letter H, letter A, from any property lot lines, minimum 50 feet from any property line.
A minimum of 200 feet from any dwelling.
That's in.
Mm-hmm.
That would indicate that it's not from your property line, it's from your dwelling. So they would be using private property for their setback.
No, I think what they're looking for here is, let's say your house is 75 feet from your property line. that they would have to, they can't just go up to the 50 feet. They're gonna have to be at least 250 feet from your structure.
So they are using your residence property for part of their setback.
If you're,
Otherwise, it would be measured from their property line to their installation. That 250 feet, not 75 feet drop. Plus the additional to make up the 250.
It's 50 feet from a property line, and it's 250 feet from buildings or structures not on the lot proposed.
So they are using your property for their setback.
Setback, then it goes further back.
Goes further back off their property than your property.
No, goes further back on their property, on their property.
If you were 70 feet from the, if you had a structure, a residential structure, occupied structure, 70 feet from the property line, where could they put their facility?
Say it again?
If you had a residential structure 70 feet from your property line, where could they put their facility?
It would be, if you're not a participating structure,
Correct.
it would be 250 minus that 70. It would be 180 feet.
So they're using that 70 feet of your property as a setback.
No, sir.
What's that?
No,
Otherwise, why isn't the setback measured from their property? Why would they measure it from my property?
basically to prevent any kind of intrusion on your use of your property.
Well, that doesn't constitute intrusion. It's using 70 feet of my property for their setback.
I think that where that comes into play is that if it's your property and you would like to build something closer to your property line within the setbacks that are required for zoning of other parcel, other different things, so you want to build a building, you wouldn't be able to because you would then be infringing on the setback from that project.
That's another scenario.
that's not what he was talking about.
It's the same thing.
That's also can be problematic.
I have to do other things, exactly what they want to do. It's gotta be a minimum of 250 feet.
They have to be 250 feet from the property.
So they use my 70 feet to make this money.
Well, what's right here, it says that they have to be decent.
No, it's 250 feet, period. It's not, and I misspoke, it's not 250 minus 50, it still has to be 250 feet away from any structure on your property.
That's
what I'm saying.
So that is using my property for part of their setback.
Well,
It's using 70 feet of my property.
if you didn't have that structure right there, then they can come up to just 50 feet from the property line.
No, so,
Right
well,
there.
it's straight because it's not a residential structure.
Right, right.
Well, yeah,
But now, with the structure there, yeah, we have back underneath.
no, they're not, they should go back 250 feet from their property line, right?
You're saying 250 feet from the
From
property
their
line, no matter
property,
what.
from their property.
Yes. I agree, I got 1,500 feet that, according to this, they can go with 50 feet off my property. If it was 250, it would bring a bigger footprint. It would be more land they would have to lease, which would benefit the people leasing it. And if I ever did want to build on your 1,500 feet, there could be several lots. It would still allow that to happen.
You know, this seems almost academic since Lori's gonna disregard the online and do what they want. There's no such thing as home rule. That's not you guys' fault for that, but
We don't have much,
You know,
we don't know how that's gonna go.
yeah, it's gonna go. It would be nice if the town had a good stand on, at least, we weren't seen to be rolling over and playing dead and, when push comes to shove.
Something else we could consider if the company comes in and wants to change that, they can negotiate maybe a variance with the property owner in town and change it to a degree of setback. It doesn't mean it's absolutely done, which knows to benefit everybody. There's positives in having it 250 feet from the property.
So the adjacent land, not the state land.
Yeah, I mean, if they got to, pay the renter 2 more acres, that's okay.
So if you make it 250 feet, it's also increasing the footprint of the solar back onto the landowning property. As a landowner, if I'm using the property, I want as efficient as possible solar on my property.
They're gonna have to pay me for these more.
I don't want to give up, I want to have the efficient array around my property, not give up 250 more feet.
Well, but, again, that's on my property line too.
It's not, it's 250 foot away from your structure, and 50 foot away from your property.
That's the problem, it's 50 foot away from the property.
Pretty standard.
It's not homestead.
What does that matter? It's 50 foot, what's the standard setback?
If they have these setbacks,
Yeah, I mean, this is uncommon, very rare.
very common setback, it's industrial installation. So I'm sure the current zoning for industrial regulations are way different than they are. I think if I recall, it can only occupy 20% of a property with industrial buildings. Now, rules, and we're talking about setting rules now. I think there's a lot of positives for doing that.
Okay, insofar as anything, any other part of this that anybody has concern about?
Somewhat more on setbacks, and Orange has already stated their setbacks from roads are 50 feet from the center line. Well, that doesn't seem to be protected with anything. That's gonna put solar panels, I don't know what the right of ways are on some of these roads. It could put it as close as like 20 feet from the road. From the edge of the road. Which doesn't make too much sense.
Well, I think, you're correct in saying that Juarez will have their own standards, which may or may not coincide with the town law. And then it's up to develop whether that's a substantial issue, that's something that have to be resolved, at that permitting phase.
Well, you're going to bat against Oregon, and the town's gonna lose that.
Well, I'm not gonna say yes or no, but, it's certainly possible. I don't understand why they would do it from the center of the right of way, because most of these roads are 66 foot wide, the right of way. So that's 33 feet right there, that's only another 17 feet off the middle of the road. Which really doesn't make a lot of sense to me, so.
It's what the Oregon standard is.
Unfortunately, we don't have a whole lot of influence with Oregon.
You may not have a whole lot of influence with Oregon, but you have a whole lot of interest how you write your zoning law. And Oregon can come in and they can squash you like a bug, and they will, but at least you can say, this is what we want, this is what we expected.
Absolutely, absolutely. Nobody's saying that we wouldn't do that.
I have nothing more than setback though.
Anything else other than setbacks
I do.
pertaining to this?
Visual screening. It's in section F. Page 7, paragraph. Now, we all know what they use for visual screening. They plant a couple rows of little evergreen trees. Is that adequate? If you bought a refrigerator and it didn't get, and you wanted to use it for 20 years, and it didn't get cold for 10, do you think that was okay? Same thing with the visual screening. They're gonna plant some great sprawling little trees. Don't do anything for 10 years. Is that adequate?
I can't answer your question. I can only tell you that in terms of the town, what authority the town has, they can prescribe what their visual screening is to be consistent.
This is where they should do it.
Huh?
This is where they should do it in the zoning law.
Well,
It's just to say that it's adequate is inadequate.
well,
You need to, you can do studies on this and say, you can look at view sheds and you can do all kinds of simulations of this. And you can say, well, this is not adequate to protect the, community.
I think it was intended to be flexible so that for each application, they would look at it, determine where it is, what it is, how big it is, what roads are there, what other structures are around. Otherwise, I can't envision saying, okay, you're gonna plant this variety of bush
I didn't say that.
every 6 inches or whatever. That's what I'm saying. If you get too specific, it may not be adaptable to a particular situation.
But-
So it's not up to the applicant to determine what's adequate. It's up to the town to determine.
In this situation is, and then it's the town's responsibility.
Yes.
The applicant knows that if their proposal is adequate, it's adequate. But if it's not adequate,
Well, I guess, that always comes down to a matter of opinion, I suppose.
it's a matter of,
I
it's a
don't
matter
know.
of sighting, it's a matter of sightlines and view shed studies and that kind of thing.
All right.
If it works, it works. If it doesn't, it doesn't.
And that's up to that would be the obligation of the planning board and its recommendation to the town board. That would be studied.
So where, has it been studied? Is it proposed to be studied?
For projects.
Is it listed in here that that will be
Yeah,
studied?
well, it's listed, it's the planning board's responsibility to review it and make a recommendation to the town.
I don't see it.
Part of, as you said, ORES, or before Article 10, part of the state requirement for any applicant is to do those studies. It is required right there. So we would be given those studies, the results of those studies. So like a visual,
And if they don't do a visual assessment?
it is required,
You can require.
yep. But it is required by the state. That is one of the many
But
research projects that they have to do
but this is
for their
our,
application.
this is our local law that doesn't just have to do with Article 10 or ORS projects. It has to do with any project. And I think that what he's saying is adequate is a subjective term. And that there are ways that we could delineate out what would be considered adequate without necessarily saying the type or variety of plants needed to be put in, but by saying like, what percentage of the view shed, what percentage of the solar array would you be able to see? What would be okay and what would be not okay for X amount of time, depending on what they choose to plant, so that they know going into it as well, that clarity for the developer. So it's not like, oh, well, all of a sudden here are really stringent regulations and then you have arguing points. I think that it's not a bad thing to delineate out specifics of what we as a town would be okay with and what we would not be okay with.
Well, then you'll have to develop some type of a standard, whatever that standard is.
That's not a difficult thing to do. There are plenty of people who do that.
Well, I mean, you say no part of the solar array will be visible from,
I didn't say that.
no, I'm just
I didn't
asking,
say
I'm just thinking out loud.
Okay.
In terms of the standard, and you say no part of it's gonna be visible from the roads. If you don't say that, then what is the standard gonna be?
Economic, 50%.
That's more than that too, it's elevation, it's contours, where you're at,
So-
it's the height of the panel, it's all sorts of things.
You're abs- you're
And where do
abs-
you stop?
You're absolutely right there too. And if you have a site that is not conducive to installing
Why
solar
not?
because the elevation and the view
That's
shed.
subjective to say not.
Yeah,
If you,
that's not the final term.
if you can't screen it because you don't think it's feasible, then the site is not
If you're
suitable.
doing a BIA from Mount Elton, like, you're never gonna screen it.
So maybe there should, maybe there should be a solar array.
Yeah, I disagree with that. Put it away.
Of course you.
That's being subjective. You're just saying, I don't think, you know, you're saying, I
You're
don't
talking
think.
about your landowner.
I think everybody should have the option, we can go to one, or we can.
Sorry. But land should be suitable for its application.
It's like, it's easy to say, create a visual impact assessment, now, you define, ORAD does a great job defining, really, it's right.
No,
You should read it, you did it.
I have. There's been nothing of a view shed analysis. No view shed analysis.
There's a whole exhibit on visual impact assessment, you should analyze, what studies and all that.
Well, if you look at these volumes, that was the original Article 10 application, and there's 2 more volumes converting it to 94C. They are very, very detailed in terms of all the studies that they have, including view sheds and et cetera, et cetera. So,
But again, we are not talking about Article 10 and we are not talking about ORs right now. We're talking about our local law for projects that are being proposed for our community. And we need to be looking at it from the standpoint of the residents and how it's going to impact them. I know when I sat in on a county planning board meeting, there was a project, and I don't remember the specifics, but they were talking about there were going to be some cars that were going to be parked possibly for extended periods of time, and they were talking about putting up a fence so that the view shed of people driving by, I believe it was on Route 31A, was not going to be impacted by these cars that were sitting there. And I think that to talk about view shed when you're talking about solar arrays, it's really not that different. You know, they were talking about putting up a fence and putting up a barrier so that people can't see those cars. You know, how I feel like for our residents, I guess I'm confused as to why it would be problematic to protect their view shed. And
I
to,
think every parcel is going to have different requirements. I think that the idea should be, from my opinion, to keep it as flexible as possible. And I think the other thing is, it sounds like there's some inherent bias against these solar panels, not like rusted out pickup trucks that are sitting in the field somewhere.
Oh,
I don't know that
it's
there's
an
anything.
industrial development in a rural environment.
Well, that's unfortunately or fortunately, that's where these things get cited. You know,
And if there are different site-specific requirements for different properties, so be it, and address them. This is not chump change we're talking about. These are millions of dollars.
I
that you're
understand.
not gonna make on.
How would you make them site specific for different locations?
Maybe someplace needs a screen berm, maybe someplace can use vegetation.
Right, so that's why.
So those are site-specific considerations.
And that's what would go into the special permit.
but do we have that in place for our projects, whether they're ORs or Article 10 or just a project that's being proposed for our community?
You have, I mean, it's in the local law, it's just not saying that, you know, you're gonna plant a tree every 6 feet, or you're gonna put in a fence that's gonna be X number of feet high, because that's all something that I think you have to look at on a case-by-case basis. That's just my feeling. You're the board, you make your decisions. The only thing I would suggest, though, is, consistent with what this gentleman is saying, it says It says under F, appropriate landscaping and or screening materials may be required. I would put shall be required, make that mandatory. And then I suppose if you wanted to elaborate, you could say, which would include, earthen berms, trees, shrubs, fences, you know. If you want to do it as a general category, that, I understand that.
And if there's a situation where the facility cannot be adequately screened, then what would you do?
They wouldn't get a permit from us. If it's an orange project, it's gonna be up to ours with feedback.
Well, you know it's gonna be an orange project.
Again, all we can do, just want to give you an example. In the wind turbine scenario, one of the things that we have to do is we have to do a write-up to show where their application differs from the local law, right? Because deference is supposed to be given to the local law. Now, what Orange winds up doing, and so, you know, we give them the information, but they make the ultimate decision. And I, you know, I realize, you know, a lot of people find that offensive, and I'm not disagreeing with you, but it happens to be the way it is. Well, it would be the same thing here. You have Orange will issue a conditional permit, and then the town and any other parties that are part of the process will send in their arguments, their briefs or whatever, say, hey, we disagree with, you know, this proposed permit condition because X, Y, and Z. And then if the Orange people think that it's a significant enough issue, they can order evidentiary hearings on it. They don't think it's a significant enough issue because they said, no, you say, we've already made up our mind, we've done 10 other applications, and this is what we come up with consistently for each one. You're right, they have the ultimate authority.
Does, the town have the right to not grant special use permit for parcels or?
Not for Orange, not for those.
So that's a useless tool to move on.
I didn't write the state law.
I know.
But it is what it is. Good, bad, or ugly.
There it is.
Mr. Lindbergh, you got any more?
I have one enough so.
Okay.
It's not really in this, there's a project being proposed, and the project sponsor has indicated that they're gonna install 1,800 acres of facility. And I'm just wondering how that's being measured when the parcels of land that have been published in the hub places, about to, maybe almost 3 times that much land. Does that mean that the project sponsors are only measuring the feet of actual solar panel, and nothing else is part of the project?
I believe it's the total number of acres of those that have signed leases, not the total number of acres that the solar panels will cover.
There is a formula. I don't know, remember what it is.
So if they're only gonna install 1,300 acres or whatever they proposed, is there a reason why they're leasing almost 3 times as much land?
Because the setback, water mountains, water bodies, they have to sit out. So you have at least 3,000 acres. You have to hope you get 5 to 7 acres per megawatt. So there's going to be 1,000 acres of fluff in there. You have to stay because of setback. So this is my point about adding the additional setback. You have a bigger footprint on these acres. But inside that these acres, you have to have all these setbacks, environmental setbacks, zoning setbacks. things that are needed to actually push your array. 3,000 acre footprint, to put a 1,500 acre array inside. Because it can't all be contiguous, because you have 4,000 certain basically what it is. You want with the tree clearing and all this thing.
I said that's not my own.
When do you reckon you'll make this current law? I mean, is that something you plan on voting on tonight?
Not tonight, no. It's gotta go to county before we can even vote on, it. See what they have to come, what they will send back to us. We also are looking at and considering your comments as well.
Will the county have a public meeting? Regarding this?
County doesn't have public.
They don't have the public, no.
They do have listed who's, on the county planning board on the website and stuff.
Yeah, and like I say, my biggest concern is that age section 8, 50 feet from the property line, just sounds too close to me. And I got some property that's in the thing. So consider it, please.
Isn't that a two-way road though? Say, if he or you want to build a barn or something like that, and setback, I don't know what it is, the setback on that, if you build a barn, it's gotta be 100 feet from any other existing structure on that person's property line. Well, now when you go to build that barn, that means that you want to have that barn have to be 100 feet from the property line. You know, if that barn is 50 feet from the property line, you gotta be 100 feet down.
Right, so if they put solar panels 50 feet off my line, I couldn't put a barn to the property.
You'd have to put it back 150 feet. It would push it back farther though, because like, so what you're saying is that, so,
What I'm saying is if you did enact that for the solar, then that should be enacted for everybody then.
His barn follows a different set of zoning, so if you whatever the current zoning says, your structure to your property, it's not changing that, the solar array 50 feet from it, then you can feet or 100 feet or whatever the zoning is from the current property line.
but other
But it's
structures,
setting,
go ahead.
no, sorry, I'm saying that would set precedent that, okay, well, then we'll set back that, but instead of just feet from those certain structures, from structures, well, now it's going to feet from the property line for anything that anybody wants to do.
That is what, so majority, like if you look through the rest of our ordinances and our zoning, majority of our zoning is from property line, because that in reality, it's where you own it. So you should be able to use your property and, you know, according to what you would like to do, as long as it fits within zoning. So there is setbacks from the road and setbacks from, you know, your property line. You can't be right on your property line when you put up a building. But with these projects, with the renewable energy projects, rather than going from property lines for setbacks, they're saying, no, we're gonna do from dwellings or from buildings, and that changes it. So there isn't that consistency, whereas before it was from property line, because that made it easy for surveys and for other things that you're going to do. And it does infringe on what the landowner who maybe doesn't have a building there, but you never know, someday may want to, can do with their land.
Yeah, I don't know if you can hear me or not. This is Teresa Baker on behalf of the AES. I just wanted to add two thoughts. The 50-foot setback from the property line is very consistent with the other types of setbacks that are in the town and are currently prescribed. And I also believe that to the extent that a property owner wants to build a structure on their property that's closer to the solar facility, that's not something that the solar facility or the town objects to. It's just that when this is initially built by the solar company, they want to make sure that from the get-go, it is a certain distance away visually from an occupied structure. So that's just part of the visual assessment, trying to protect, surrounding property, particularly occupied residential property from visual impact. And one thing that's kind of missing through here, and it does not apply to ORIs and it does not apply to Article 10, the State Environmental Quality Review process has a visual impact assessment document that DEC requires every seeker lead agency to implement. And that visual impact assessment provides for line of sight drawings, and it also provides for visual simulations and visual screening to screen views to the maximum extent practical. So that standard already exists in the seeker law, which applies to the small solar projects, not like the ORIs and the Article 10 project, and which is implemented by the planning board anytime, or the town board anytime they act as seeker lead agency. So I just wanted to throw that out there. There is a process for assessing visual impact for all projects.
Thank you, Teresa.
This zoning law itself is subject to seeker.
Yes.
Have you folks applied to seeker for submitted an EAF for them to determine whether this is a significant action?
We, as the lead agents, well, wait a minute. With the law itself, the town board does the seeker. So it's not the DEC that does the seeker, we do the seeker on it.
I didn't realize that could be done. But if you say so.
It's a town law, so
So.
we can do the seeker on it.
Supersedes state law?
Supersedes it?
Consistent with state law.
So you have a negative declaration?
We have in the past, yeah, on this one,
And
yes.
it's just, you just did it yourself?
Yeah.
Cool.
So the town sends letters to lead agencies requesting, soliciting that if they want to, lead agency or a co-lead. Those letters, I assume, were sent for different projects, DEC, Fish and Wildlife, Army Corps,
Have they been sent to this project?
I don't know if this project is.
This, remember,
This
we're
is
talking,
project.
excuse me, gentlemen, we're talking about the law.
Right, the zoning.
We're not talking about any specific project at all.
The zoning law is subject to seeker.
Yes. And we bought, in this last, our last workshop, we went through and did the seeker and performed the seeker, all the questions, answered them. The town board went through them all, and we have that all set at this time.
So you have a EAF and a negative declaration.
That's what we have at this time, yes.
We didn't vote on it.
We
It
haven't
was a work-
voted on it, but
We don't
that's
have-
what we have talked about, yes. That's on the agenda for tonight's board meeting for a vote on it. Anybody else? Okay. And I thank you, everyone, for coming out, participating, giving us your feelings on certain components of this proposed change, and we'll take it all into consideration. Okay? Thank you very much.
Thank you.
And that's it, close the hearing.
Um,
You can definitely But I mean, it's a contest.
I
Do a
move,
resolution?
I move that the meeting, open, our public hearing is closed.
Second.
Margaret seconds. All in favor?
Aye.
Opposed? So carried. Six forty-nine.
This one. I think it was on the folder. I passed it down to you. I passed it down. I think your folder was open at the time.